discussion going on the resolutions. I'm going to read them all into the record. We'll start with the amicus brief resolution. It's written on the top. You're writing. Okay, I'm going to start on the second page, the first whereas on page 2. Whereas various states, including New York, Colorado, and Nevada, have attempted or are attempting to exert regulatory authority or jurisdiction over western skies on reservation business activities, and by extension over the loans it makes. None of the states have such authority. To this end, and unlike state sovereignty, the tribe's sovereignty is achieved and protected through two separate but related immunities. One, sovereign immunity of the tribe, its arms and its officers, which has no territorial bounds. And two, the general derivative immunity of the tribe members from being forced to live by non-tribal state law, which, while present on the reservation. This case is about the latter. Western Sky is a business solely owned by an enrolled tribal member, advancing the congressionally recognized purpose of promoting the tribe's sovereignty and self-sufficiency through economic development on the reservation. The tribe has sole regulatory authority over Western Skies on reservation business activities and any disputes related to it. And whereas Western Sky is a business solely owned by an enrolled tribal member, advancing the congressionally recognized purpose of promoting the tribe's sovereignty and self-sufficiency through economic development on the reservation. The tribe has sole regulatory authority over Western Skies on reservation business activities and any disputes related to it. Now, therefore, be it resolved, the Cheyenne River, or that the tribal council hereby, that the tribal council, strongly condemns the actions of state regulators infringing on the rights of the CRST and its members to make their own laws and be ruled by them. And be it further resolved that the CRST tribal attorney and/or outside counsel is hereby authorized and directed to file amicus briefs in the various state and district courts as necessary to assist economic development and protect the rights of the CRST and its members to make its own laws and be ruled by them. Be it finally resolved, the disclaimer. Second one. Jurisdiction and sovereignty. Go to the second page is the first whereas. Whereas the Tribal Council has authority, i.e. jurisdiction, pursuant to Article 1 of the Tribal Constitution as follows. Article 1, territory. The jurisdiction of the Cheyenne River Sioux Tribe of Indians shall extend to the territory within the original confines of the diminished reservation boundaries, which are described by the Act of March 2nd, 1889, and including trust allotments without the herein mentioned boundaries and such other lands as may be hereafter added thereto under any law of the United States, except as otherwise provided for by law. See Solon v. Bartlett, 465 U.S. 463 104. State Court, I think that is what it is, 1161 79 LED 2D 443 U.S. 1984, affirming the northern and western boundaries, reservation boundaries. See also State of South Dakota v. Duchno 1990, WL 605077, DSD August 21st, 1990, number civil 88-3049, affirming the southern eastern reservation boundaries. Hence, the reservation boundaries remain as they were set forth by Congress on March 2nd, 1889. The reservation boundaries remain as established by Congress. Neither the federal courts nor Congress have diminished or disestablished these boundaries. The territorial jurisdiction of the tribe is the same as the reservation boundaries set forth in the Act of March 2nd, 1889. Subsection 4, no other state regulator has authority within the territory of the CRST reservation. Whereas regulators in several states have threatened to crack down on payday and installment loan companies, much to the chagrin of the Native American tribal lenders and those who have argued that such loans serve a necessary purpose in the financial market. Whereas the tribal code provides that unless there is federal law to the contrary, the tribe asserts jurisdiction over all actions wherein the persons are present or residing within the boundaries of the reservation, including corporate entities transacting business possessing property on the reservation. Subsection 1-4-1, 1-4-3. Whereas various states, including New York, Colorado, and Nevada, have attempted or are attempting to exert regulatory authority or jurisdiction over Western Skies on reservation business activity, and by extension over the loans it makes. None of the states have such authority. To this end, and unlike state sovereignty, the tribe sovereignty is achieved and protected through two separate related immunities. One, the sovereign immunity of the tribe, its arms and its officers, which have no territorial boundaries, and two, the general derivative immunity of the tribe members from being forced to live by non-tribal state law while present on the reservation. This case is about the latter. Western Sky is a business solely owned by an enrolled tribal member advancing the congressionally recognized purpose of promoting the tribe's sovereignty and self-sufficiency through economic development on the reservation. The tribe has sole regulatory authority over Western Skies on reservation business activities and any disputes related to it. And whereas Indian tribes are domestic dependent nations that exercise inherent sovereign authority over its members and territories, Oklahoma Tax Commission versus Citizen Band of Potawatomi Tribe of Oklahoma, 489 U.S. 505, 509, 1991. As sovereign nations, Indian tribes retain considerable control over non-member conduct on tribal land. See also Montana v. United States, 450 U.S. 543, 544, 1981, stating that with respect to on-reservation conduct, the tribe may regulate the activities of non-members who enter consensual relationships with the tribe or its members through commercial dealing, contracts, leases, or other arrangements. Whereas Congress has acted consistently upon the assumption that the states have no power to regulate the affairs of Indians on a reservation. Williams v. Lee, 358 U.S. 217, 220, 1959. The policy of leaving Indians free from state jurisdiction and control is deeply rooted in the nation's history. McClanahan versus State Tax Commission of Arizona, 411 U.S.C. 164, 168 of 1973. Quoting Rice versus Olson, 324 U.S. 786, 789 of 1945. Thus, absent governing acts of Congress, the question has always been whether a particular action by a state infringes on the right of reservation Indians to make their own laws and be ruled by them. Whereas various states have attempted or are attempting to exert regulatory authority or jurisdiction over CRST and its members, CRST is an Indian tribe and domestic dependent nation that exercises inherent sovereign authority over its members and territories. Oklahoma Tax Commission versus Citizen Band of Potawatomi Tribe of Oklahoma, 498 U.S. 505, 509, 1991. As sovereign nations, Indian tribes retain considerable control over non-member conduct on tribal land, and therefore be it resolved that the Tribal Council strongly condemns the actions of state regulators, including those who have threatened or brought enforcement actions against Western Sky for infringing on the rights of the CRST and its members to make their own laws and be ruled by them, and be it finally resolved. A disclaimer. Third one will be the Uniform Commercial Code. We'll go to page 2, the first whereas. Whereas the UCC was adopted by Tribal Council on February 5th, 1997 via Resolution 53-97 CR. Under the UCC, the provisions of the 78 CRST Law and Order Code were required to be construed in light of the tribal statutes existing at the time of enactment of the UCC Resolution 53-97-CR adopted UCC subsection 1613-112, which had affected the Law and Order Code subsection 3-4-52 usury and 3-1-3 subsection 2 criminal usury by the enactment of the UCC subsection 16-13-112, which mandates that interest in a loan may be written if the term of interest is equally negotiated by the parties to the loan. Now, therefore, be it resolved that Tribal Council hereby takes notice that Western Sky is a business solely owned by an enrolled tribal member whose operations do not contravene law and order. Subsection subsection 3-4-52 usury and code subsection 3-1-3 subsection 2 criminal usury, which have been superseded by enactment of the UCC, and furthermore to advance the congressionally recognized purpose of promoting tribe sovereignty and self-sufficiency through the promotion of economic development on the reservation. The tribe has sole regulatory authority over western skies on reservation business activities and any disputes related to it. Be it finally resolved at this time. There they all are.